Assalamualaikum warahmatullah. This video will discuss damages for personal injuries. So previously, we discussed motor vehicle accident. So when a person had an accident, not because of their fault, and suffered a personal injury, that person may decide to bring an action against the negligent person and claim for damages for his personal injury. So the purpose of damages is to compensate the plaintiff, i.e. the claimant, and to put the injured person back in the position he would have been had the accident not taken place. And this is based on the principle of restitutio in integrum. So all of you already know that damages is a monetary compensation. So it is awarded by the court after the plaintiff, i.e. the claimant, succeed in proving his case against the defendant. Meaning, the plaintiff needs to show that the defendant's negligence caused the personal injury, and the injury must not be too remote to be recoverable. The next question is, what's the law in Malaysia that governs matters on damages for personal injuries? First, you need to know that the Malaysian law on damages for personal injuries has its origin in the English common law. However, there are some changes to the law due to the Civil Law Act 1956 and the Civil Law Amendment Act 1984. The law that governs damages for personal injuries is Section 28A of the Civil Law Act 1956, read together with Section 28A by the Civil Law Amendment Act 1984. However, there are few cases where the court held that the English common law is applicable when it comes to the assessment of damages for personal injuries. The first case is the case of Jack-Singh. In this case, the Privy Council held that the law as to the factors which must be weighed and considered in assessing damages was the same as in English law. Then the case of Jamil bin Harun. So in this case, the issue was whether the court may apply the English law in determining the amount of damages. In this case, there are two respondents, one named Yang Kamsiah and the second one is Yang Salbiah. They are both sisters and infants. Both of them were run down and injured by a bus driven by the appellant, i.e. the defendant. Both girls, acting by their father, sued the appellant. The first respondent, i.e. Yang Kamsiah, her injuries were not serious and she managed to settle her claim. However, Yang Salbiah, the second respondent, she suffered a serious injuries that caused her permanent mental and physical disabilities. So the case went on appeal to the federal court. The federal court held that it is necessary for the court to itemize its award, i.e. to make a separate assessment under each head of loss of damage. The federal court followed the decision in the English House of Lords case, i.e. the case of Lim Poh Chu. So, in this case, the appellant appealed to the Privy Council on the ground that it was wrong to itemize an award for damages in personal injury cases. The appeal was dismissed and the federal court decision was held to be right. So we can conclude that the English common law is applicable when it comes to the assessment of damages for personal injuries. In cases of personal injury, the plaintiff may suffer two types of losses. Okay, number one, the plaintiff might suffer pecuniary losses, which means the actual financial losses. Number two, the plaintiff may suffer non-pecuniary losses. So we will divide the discussion to number one, special damages, and number two, general damages. The focus would be on the assessment of both types of damages. The first one is special damages or pecuniary damages. Special damages is a compensation for financial losses resulting from the accident. I repeat, special damages is a compensation for financial losses resulting from the accident. When claiming these damages, the plaintiff needs to provide sufficient evidence in order to support their losses. The losses or injuries usually can be calculated and need to be specifically pleaded by the plaintiff. For example, let's say we take the same example as before. Let's say A negligently drove his car and caused B to suffer a broken leg. B is a football player. Let's say that he is paid 20,000 per month. As a result of the accident, B could not work for a year. Okay, his medical bills amount is, let's say, 50,000. So the court will look at these facts in deciding the damages and the amount of damages that should be awarded to B. So the special damages would be 20,000 ringgit multiplied 12 months. So it will be 240,000 ringgit plus medical bills 15,000. So the amount of special damages that might be awarded is RM 290,000 ringgit. So the assessment for special damages is more straightforward compared to general damages because it takes into account all the expenses the plaintiff has incurred. Okay, so as I've mentioned before, special damages need to be specifically pleaded and proved, meaning the plaintiff must state the amount of damages that he wants to claim and prove it. For example, if the plaintiff wants to claim out-of-pocket expenses, such as medical expenses, the plaintiff need to tender the medical bills to the court. The court will look at the proof given and will decide whether to allow special damages or not. And if yes, the court will decide the amount of damages that should be rewarded to the plaintiff. So these are some cases where the court emphasized the importance of specifically pleading special damages in their statement of claim. Number one, the case of McGuinness, where the court held that items of special damages must be specifically pleaded. If omitted, the plaintiff must amend his statement of claim to include the items. Similarly, in the case of Ong Ah Long, where in this case, the judge held that the plaintiff must plead the exact loss. In other words, the precise amount of items of damages. This is actually to ensure that both parties are prepared for the trial. Next, a duty is imposed upon the plaintiff to take reasonable steps to mitigate the losses suffered by him. If the plaintiff fails to mitigate his loss, he might not be able to get the claims for those losses which could have been reasonably avoided. In the case of Batu Mali, the plaintiff had claimed the full amount of RM742.25 for treatment sought at a private hospital. But the session court judge only granted RM250 on the basis that he should not have sought treatment there after his initial treatment at a government hospital. On appeal, the High Court held that the plaintiff must be allowed to seek medical treatment in a private hospital and not only from the government hospital. The High Court stated that his initial treatment at the General Hospital of Klang was an act of mitigation itself. He only proceeded to the private hospital upon the advice of the government doctor. His action, therefore, were justifiable and reasonable. So the claim of RM742.25 for medical expenses incurred was therefore allowed. Then the case of Muhammad Saad Mat. In this case, the respondent had refused treatment at the hospital and discharged himself. He then delayed seeking treatment. So the court, in this case, reduced the amount of damages to RM17,000. Lastly, I've already explained the example of special damages. The example of special damages including loss of earnings and out-of-pocket expenses. So these are some of the cases that illustrate these claims. So out-of-pocket expenses includes medical expenses, transport and nursing care. For example, you can see the case of Siti Rahmah binti Ibrahim, which involved claim for nursing care. In this case, the court awarded RM350 per month for the cost of caring the plaintiff who suffered as a result of brain surgery. So that concludes topic 8. Next, we will discuss general damages. Okay, thank you.